Hello, everyone. I'm going to try this lecture without my glasses on because when I looked at the playback, it appeared that the screen was kind of flashing off of my eyeballs. So um, I know you haven't seen me without my glasses before, and thank goodness I don't have to see very far because I'm legally blind without them. To summarize the first lecture, I went over the overviews again, and I talked about jurisdiction. So if there are any questions about that first video, make sure that you email me so that I can spend a little bit of time in question and answer to answer this to the whole group. Today I want to review how presidents nominate Supreme Court justices. And even though I talked about this in class at some length, I only finished 3 of the 4 criteria. So I will very, very quickly go through the first 3 criteria and then get to the 4th one that I haven't talked about yet. Remember, the first criteria was that presidents choose Supreme Court nominees based on policy preferences, right? They want nominees who see the world the way they do. They don't always get it. As I mentioned in the first presentation, presidents only get the type of nominee they think they're going to get about 80% of the time. But usually presidents get what they think. So not only do they want someone of their political party, but presidents may have a specific issue they're interested in. For example, Andrew Jackson was really interested in states' rights, and that's why, remember, he nominated Roger Taney to the court. Richard Nixon saw himself as a law and order president. Ironically, given what happened to him, that is kind of laughable a little bit. But he put people who on the court would give the police a lot more power to investigate criminal activity. Bill Clinton was a Roe versus Wade guy. He wanted to put nominees on the court who would uphold the landmark Roe versus Wade abortion decision. Besides policy preferences, presidents also want nominees that are competent and that are ethical. So, for example, I talked here, remember, about the American Bar Association rating, that the American Bar Association ranks nominees based on competence, and their criteria is they rank them either well qualified, qualified, or not qualified. And as you might guess, routinely, nominees are going to be rated well qualified. All 9 of the justices that are currently on the Supreme Court, all 9 of them received a unanimous well qualified rating from the American Bar Association. Whether they're liberal or whether they're conservative, that isn't what we're talking about here. We're talking about, are these people qualified to do their jobs? And so the 9 justices on the court have all been rated as well qualified by the ABA. The example that I gave in class of Clarence Thomas and Anita Hill illustrates really the only controversy that I can think of in my lifetime where there was actually a question about both competence as well as ethics. A couple of the panelists on the American Bar Association panel ranked him not qualified. He ended up getting a majority qualified rating. None of the panelists ranked him well qualified, which certainly looked very, very different than the vast majority of nominees. Of course, Clarence Thomas also had that controversy, remember, note with Anita Hill, who alleged that Judge Thomas had engaged in sexual harassment when she worked for him at the Equal Employment Opportunity Commission. And so the nomination became a he says, she says, and essentially the referendum was, who do you believe? So senators were telling their colleagues, hey, if you believe Judge Thomas, vote for him. If you don't believe him, vote against him. The Senate was very, very narrowly divided. And as I pointed out in class, the vote was 52 to 48 to confirm Thomas. And Thomas was confirmed, and he was placed on the bench. The third criteria, the last of the review items before I begin new material, is political reward and political support. And I pointed out that presidents, especially in their first term, are looking not only for a nominee who checks the bars for them in terms of things like, do they see the world the way I do? Are they competent? Are they ethical? Are they going to represent me well on the court? But also, could the nominee do something for me? And you may remember I used two examples in class. The first was Ronald Reagan. Reagan nominated Sandra Day O'Connor to the court. His political advisors told him, Mr. President, we have an image problem with American women. Reagan asked, well, what do you suggest that I do to try to correct this? And they go, well, Mr. President, we suggest that you nominate a woman to the high court. And so Ronald Reagan made history. He became the first president to nominate a woman to the Supreme Court. Reagan and his people were hoping it would help him when he ran for re-election. The same thing happened for Barack Obama. Barack Obama, like Ronald Reagan, made history. He nominated the first Latina to the court, and he too was hoping that when he ran for re-election, this nomination would help him. But in both cases, the nominees were competent, they were ethical, and both of them pretty much represented the views, the policies of the president that nominated them. The last one, and here is where the material starts out new. So if you've got your notes in front of you, this would be number 4, Judicial Philosophies. And essentially, by judicial philosophy, the question here is, what role do the justices believe the courts have in the system? In other words, should they be active? Should they be more passive? Should they defer? And the two broad philosophies are judicial restraint. Judicial restraint, and of course the word restrain means to hold back. Essentially, the philosophy here is that judges should defer to popularly elected institutions of government. Essentially, what these people are saying is people vote for representatives, whether it's city council people, whether it's their county board of supervisors, whether it is their state legislature, or whether it is their Congress. In this particular case, people vote for representatives to make the law for them, not judges. So these judges say that we should defer to these popularly elected institutions. Now, obviously, you can't always do this. These judges say, but we should declare things unconstitutional as seldom as possible. We should do it on as narrow a basis as possible. And obviously, if the institution goes completely out of bounds, if the actions are clearly illegal or unconstitutional, it's our job as a judge to strike that law down and to get them back on the playing field. But the assumption here, and what's key is, what these justices do is they respect that concept of majority rule. You remember that I began this course with that paradox of democracy, which I personally believe is that at times majority rule is not compatible with minority rights, and these judges lean very, very strongly towards the concept of majority rule. The other judges, the judicial activists, believe that the courts are there to be a tool to protect oppressed minorities from majoritarian tyranny. And essentially, the argument summarized by these judges is quite simple. The argument of these justices are that if you take a look at executives, whether they're mayors, whether they're governors, whether they're presidents, or whether you look at legislatures, city councils, state legislatures, or the Congress, all of them are subject to the whims of the majority. These people are elected officials, and as such, their goal is going to be re-election, and therefore they are going to be very, very sensitive to the desires, the whims of the majority. The judges who believe in judicial activism make the claim that if in fact democracy is this paradox between majority rule and minority rights, the only institution that is capable in American government of providing that balance would be the courts. It is only the courts that go beyond the pressures of the ballot box, and only they can provide that balance in terms of, on a regular basis, protecting the rights of the minority from a majority that may not want to respect or may not want to extend those rights to them. So this is not a matter of being conservative or liberal. I read a very intriguing research study by Bruce Murphy, who was a professor of political science at Ohio State University. Professor Murphy's expertise was the judiciary, and Professor Murphy really examined and analyzed this assumption that you often hear if you listen to talk radio, or even if you listen to television shows like on CNN or MSNBC or Fox, because a lot of commentators make this assumption that it is conservatives who believe in judicial restraint, and it's liberals who believe in judicial activism. Professor Murphy's research study was very, very intriguing because he said there was not a statistically significant difference between conservatives and liberals when it comes to restraint and activism. He said, interestingly, it is the conservatives that are very slightly more activist than liberals, but the difference was not enough to be statistically significant. And so this assumption that we often hear about conservatism being linked to restraint and liberalism being linked to activism does not appear to be true. And I've looked at other research articles by other judicial scholars, and they come to similar conclusions as Professor Murphy. So in conclusion for this short 15-minute lecture, and I'm going to try to do these lectures in 15-minute segments so that you can stay somewhat focused. You can take a break away from them easily. So in this lecture, I was trying to get across what is it about a nominee that is going to get a president to nominate them to the high court. And we tend to see four criteria. First, the first and the most important when I ask you on the exam is policy preferences. A president wants a Supreme Court nominee who would view the law the way that they do. Second, they want a nominee who is very competent, who is very ethical, who is going to represent them well on the court. Third, if the president is in their first term, they want a nominee who might help them politically when they get reelected. And finally, the fourth, the last criteria, is the president might be interested in how do the justices view their role as a judge. Do these judges believe in judicial restraint? In other words, these judges believe that they should defer to the president, defer to the Congress, defer to governors, defer to state legislatures, or are they judicial activists? Are these judges going to go out there and protect minority rights and be a tool to protect minority rights on a regular basis? So that is the conclusion of the second lecture on the judiciary. When I come back in lecture number 3, we're going to actually decide a case, and I think I've got a really good Randall story for you. So look forward to the next lecture. Take care. Bye-bye.